listeners and spectators, so let's groove with the smooth operator. Just sound so smooth. Just sound so smooth.
Folks, are you there? This is your main made man, attorney at war, Stephen G. James, and this is your show, The Hour of Power, and you are now rocking live from NYC on the worldwide broadcast, heard around the globe, from Russia to China, from the United States to Europe, to the continent of Africa and Asia. We have people checking in from all over the world. Happy Saturday to you, and once again, another week under the belt. God bless you for joining in. Who do we have checking in today? Oh, by the way, good people, let me let you know that my main engineer, Mighty Joe Young, LL Cool Joe, otherwise known as Joe Swift, is on assignment and cannot be here with us today. But your main made man is here to drop some of that science on you and have some of you guys drop science on me. So hit me up and let me know what's good. I'm broadcasting from a different location from our normal studios. Next week, we'll be traveling to South America and Latin America. So I'll try and get the broadcast from there as well. We're going to keep this party going, you know, no matter where I'm at, no matter what I'm doing. Saturday from 12 to 1, your hour of power is for you. Who do we have checking in today? Sub Singh. What's up, baby? Checking in from India. Peace, brother. Checking in from India. And I appreciate you, Sub. I know it's about 10 o'clock at night there. It's 10 p.m., so I appreciate you checking in with your main made man. Also, we have Victor Mercado and Willie Lely checking in too. Appreciate you. Tanya Lofton, okay. Sub Singh says, nice looking. Thank you, brother. Appreciate that. You know, I am broadcasting high atop New York City in the penthouse today. Normally, I don't broadcast from here, but since Mighty Joe Young is not with us, LL Cool Joe is not here, I figured let me try to do it myself. So I'm my own engineer, so you'll have to bear with the Playboy, okay? Who else is checking in? Let's see. I can't even read this, y'all. Hold on. Let me see. I better put my reading glasses on. Angela Robinson, good morning. Yes, good morning to you, sweetheart. It's very nice to hear from you. That's our banker in the bunch. Angela Robinson checking in from Texas. How are you? I'm doing fine. And yourself? How are you doing? And Joyce Thomas, JT is in the house. JT says, good morning. Y'all, you know it's afternoon, right? Oh, but then you're all in a different time zone. That's true. In New York, Eastern Standard Time, it's 12:15-ish. But I know some of you guys are checking in from Pacific time and West Coast time, so it could be as much as 3 hours difference. So I understand. Good morning to you all on the West Coast and in places like Chicago, who are about an hour behind us in New York time. So good morning. But it is 12:20 here in the Big Apple. JT, thank you. We have Seti Goraya Bay, Hotep brother Madigani. All right. Tanya Lefton, good afternoon. Okay. TL, good afternoon to you too. What's good, guys? What's good in the news that y'all want to talk about today? Because I know that there's a lot of stuff I want to talk about. But your hour of power, of course, is only 1 hour. So, and, you know, we try to steal a few more minutes here and there where we can get them. But the bottom line is we got to keep it moving and grooving so we can keep that information flowing. You know it? Who else is checking in? Ike Diesel from the West Coast, California, IA. Ike Diesel, what up, Playboy? You know how we do. When I get out there to LA, I'm going to holler at you. All right. We have Elaine Tyndall, cousin Elaine. How you doing, little cuz? And who else is checking in? Deidre Cobb, Debbie Cobbs. How are you, Deborah Cobbs? Good to see you. Y'all, I'm in a different environment now. It's a lot brighter, so I have a hard time sometimes reading some of the words and some of the names, but everybody's checking in. And let's see. Let's bring it a little bit closer. Angela Robinson, you doing? Oh, thank you. See, now y'all gonna make me blush. I'm doing an awesome job. I appreciate it. It's me by my lonesome. Well, it's all three of us, me, myself, and I. Your main man, the professional. And of course, Attorney at Law Stephen G. James. And this is your hour of power, and let's jump right into it. Naturally, national legal practice. Yes, we go all over the country, and in fact, all over the world. We have been in different countries hustling this trade and doing what we do, trying to save lives and working for you. So praise be to God. Amen. 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 Terry Perry, good morning. Junior Tavares de la República Dominicana, checking in from Santiago, Dominican Republic, Gurabo specifically. How you doing, Junior Tavares? Sharon Key, good morning. James Holt, good morning to you. Terry Perry. Wow, we got the gang. Everybody's checking in today. Guys, let's jump right into some questions. Let's jump right into some answers. Let's jump right into the conversation. That's why we come together every Saturday, right? To chop it up and to make it happen. So let's do that right here and right now. How many of you guys have tried to buy or sell properties or land or buildings or apartments, or if you're in New York, things like condominiums, or if you're in Dominican Republic, maybe some farmland, things like that? Anybody bought or sold any land recently? Or even not recent, but may have any issues about that? Because I wanted to talk about some of the pitfalls, the ups and downs. And I know that Angela Robinson is a banker, so she deals with financing a lot of things that are purchased and sold in the community out there in Texas. So if you have any specific professional insights to join in, Angela, please, by all means, join in. I also happen to be a licensed real estate broker, you guys. So I know a little bit about real estate, and I've been practicing in the area of real estate for over 30 years. So one of the things that occurred this week was that I had some clients who came in and they had an issue with a closing. I was talking with, although I wasn't involved in the transaction, it was the sellers who had the problem, and they had a lawyer who didn't know how to resolve it. What happened is that they had gone to an attorney to sell a piece of property. It was a husband and a wife. However, the wife had started suffering from dementia and things related to her inability to emotionally and mentally deal with her affairs. It was the onset of dementia, so it was the beginning stages. She would forget a lot of things. Sometimes she'd forget who her husband was. Sometimes she'd forget her own name. She had no children or anything like that, but certain people who were very close to her, she'd forget their names and really would be at a loss for who they were. And then sometimes that memory would come back and everything would appear fine. So she had the onset of dementia. Some people would call it even Alzheimer's to some degree. But the point is that she was showing signs of mental breakdown and some level of incapacitation. Now, when they got to the closing table, the lawyer who was representing them, although she had been told by the husband of these signs of mental incapacity in his wife, she apparently ignored them and felt that maybe a power of attorney, a POA, as we say in the law, a power of attorney would be sufficient to get the job done and get the documents signed and move forward with the closing. Well, the bank's attorneys stopped the deal as soon as they became aware of this at the closing table. Yes, all the parties were there. Buyer, the seller, the attorneys for each side, not me, the bank's attorneys, the closing person from the title company, and the bank itself was represented. And they stopped everything with all the parties there. The money had been funded. The loan was there for the buyers to make the purchase. Everything was set except one thing. The attorney for the party with the incompetent wife, the attorney for the sellers, had not properly assessed her situation and did not get what is needed in law. In this case, the attorney thought a power of attorney would be sufficient. No. What they needed was guardianship. By that, I mean they needed to go into surrogate's court in their state, in this case, the state of New York, but this would apply across the country, and get a proceeding called guardianship of the incapacitated person, in this case of the wife, who in fact, not only was she an age of majority, she was a senior. She was older than her husband by about 12 years. And I think she was in her early 70s. And she was suffering from dementia, and they needed to get court approval for her husband or whoever would be the moving person for the guardianship to become the guardian of her property, of her estate, of her blah, blah, blah. And they hadn't done that. They had gotten a simple instrument called the power of attorney, which in short form is a document, and I'm sure Angela and others in banking know about this, that you can get either from a bank, through an attorney, prepared by an attorney, or sometimes even on your own if you're familiar with the legal requirements in your state to prepare a POA. And it gives the power of handling legal business, banking, certain financial affairs, paying bills, things like that, from a grantor to a grantee. The grantor is the person who's given the power to a grantee, the person who's accepting the responsibilities of the power and who's going to be executing things on behalf of the grantor. Well, that's an instrument that's fine as long as both parties are competent, you know? And the power of attorney is only good up until the time of the death of the testator or the grantor, or if and when the grantor revokes the power, which can happen at any time. Anytime you give a power of attorney to someone, you have the right unequivocally and unabashedly to revoke that power, and it returns back to you, and you do your affairs on your own behalf. However, the other way a power of attorney becomes null and void, if you will, not when there's a death of the grantor, not when the grantor revokes the power during his or her lifetime, but the third way is if the grantor becomes legally incapacitated, emotionally, mentally disabled. And that's what happened here. So when the person is mentally disabled, a power of attorney is not the proper instrument to execute because that person is legally incapacitated. Therefore, they're not competent to give the power over of their affairs, of their financial affairs, of their medical affairs, decision-making, blah, 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 to another person. They're not competent to do it. So a power of attorney is not the proper instrument to execute. And that lawyer made that mistake and had that executed at the closing, and no one would accept it. I think it was the bank's attorneys who said no. I think the borrower wanted to go forward with the deal regardless. He wanted to buy the property and move on. But the bank's attorney said no. Do you know why the bank's attorney said no, good people? The legal reason why the bank's attorney said no, among other reasons, in addition to it being the improper instrument, is because at closings, you're executing a lot of legal documents, and the buyer is obligating himself through an instrument called a mortgage. You know what I'm talking about. Diana DeYoung, my little cousin's checking in. How are you? You obligate the borrower through a mortgage. Well, if the borrower is obligated, that means the transaction has to be legal. And the bank is protected by having a mortgage, a lien, if you will, on the property that is being borrowed against. The property is the collateral. The mortgage note is the legal instrument that acknowledges the lien on that collateral based on the amount of money that's being borrowed, called the loan. Now, if the seller or the borrower, any part of this transaction, is incompetent, that means the entire transaction becomes null and void because the contractual part of it that the seller or the borrower or the incompetent person, whoever side they're on, in this case it was the seller's wife, signs, it's not a legally binding contract. So the bank, in essence, would have been at risk in lending this money to the borrower, closing the deal, and then later on the borrower saying, look, this transaction wasn't legal, she was incompetent, and there was no court adjudication of her incompetency, giving her husband or anyone else guardianship over her to transact this transaction on her behalf. So I'm not going to pay the loan back to the bank, and I'm keeping my property. You follow? And the only thing that they may pay may be the down payment or whatever they lost in the transaction, but the bank is on the line for the entire amount that they financed of that house. So the bank's lawyer properly stopped the transaction and said, heck no, we won't go. You're going to have to go and do this properly. So what they did was, after that problem and the closing didn't happen, they came to me. Why don't they ever come to me with the simple stuff? They never do. So that's how they ended up in my offices earlier this week. And I explained to them what I just explained to you guys about guardianships and how the POA, the power of attorney, was the incorrect instrument and how they had to do it a certain way. And basically, the process now goes to surrogates court. That takes about 9 months to a year if it's done quickly. And then once the guardianship is approved by the court, and it should be, absent any unforeseen circumstances, it should be approved. Once it's approved by the court, then we can come back and close this transaction out with a guardianship versus a POA. But that was one of the problems. Earlier, there was a situation where there was a guardianship underfoot, and the person for whom the guardianship was being sought, the incapacitated person, died during the processing of the guardianship, during that year period that it takes for a guardianship to be approved. And the death of the ward, the person for whom guardianship is sought, the death of that person nullifies and voids out the transaction. There is no guardianship issue once the person for whom you're seeking guardianship passes away. So if you have guardianship and they pass away, it ends there. And if you are seeking guardianship and they pass away before it's actually determined, that process stops. But then you can also look if that person had a will for after death issues. That's a testamentary instrument. And that deals with things that occur from the point of death forward. How do we settle their affairs, their debts, the funeral arrangements, et cetera, et cetera. And that falls on the executor or executrix, male and female, of the will. So if you guys have any questions about trusts and estates, wills, guardianships, guardian ad litem, power of attorney, things like that, chime in, okay? Now let's go back and see who's out there. Amelia, ¿cómo tú estás? De Hempstead. I didn't see you there before. Amelia Carolina Velázquez de Colombia. ¿Cómo tú estás? Un placer a verte. Bienvenidos. Irvin Hester, little cuz, Sharon Key, how are you? Checking in. Wow, we got a lot of folks in here today. Angela, are willing to take cases in Texas? Of course, I'm willing to take cases all over the place as long as I can waive into the jurisdiction, meaning I don't have a license in that jurisdiction, but under certain circumstances, the court will allow me to come in and transact on an individual basis cases on behalf of clients who prefer my services versus someone in that jurisdiction that's admitted already. But there's a small process. It's not a big deal, but I can definitely do it. Yeah, Joe's not here. I'm doing an awesome job without him. Thank you. Thank you. Stephanie Ray has checked in. Hi, Steph. Joyce Thomas, JT, Sub Singh. Thank you, guys. Sandra Herman, how are you? Spoke to you this morning. Sharon Key, James Hall. Junior Tavares. Van Wilder. Good morning. Irvin Hester. Diamond DeYoung, my seller died before closing and my side went through surrogate's court. Almost lost the purchase. Yes. I'm sorry I didn't see your question, Diamond DeYoung, when I was talking about that. But yeah, that can happen. So it's very important to, get the right attorney. Let's start with that premise. Because the right attorney can, foresee some of the pitfalls in any individual transaction, and B, know how to deal with them when they pop up. You know, if it were me, for example, and the seller dies, but you have a signed contract, which clearly you had, you can do a forced sale. You can force the estate to continue through the transaction. And if you're still listening, Daim, I want you to check back in. Tell us how you resolved it. Was it did you force the estate? Did they give you a problem, or were they willing to go forward with the transaction and sell the property? Did they try to change the price? Let us know exactly what, if any, problems occurred and how they were resolved. And next time you know where to come, your big cousin. You got a cousin like me. How do you not come to me for everything? I'm only teasing. I know I was in Florida at the time you were doing this transaction, so praise you, and I know that everything worked out. But let us know how it did go, because we're speaking to the whole group around the world on how to resolve these problems. Irvin Hester. Hey, are you going to Daim? Mr. Hester, how many times do I have to tell you that personal questions like that are inappropriate for a worldwide international broadcast like this? You know my phone number, mister. Pick up the phone and talk to me about barbecues. That's my little cousin, y'all, Irvin Hester. Let me yell at Born King Allah real quick. Don't call with stuff like that. Let's talk. Let's stay on topic, boy. But I am leaving the country tomorrow morning, and unfortunately looks like I may not be here on that date. But cousin Daima knows that I will definitely be at the next one without a doubt. And I'll be at the Jam Fam Entertainment Group's function this evening, y'all. Don't forget about that. This evening in New York, Jam Fam Entertainment Group is putting on a Latin dance party. Big, giant party here in New York. Be there or don't be anywhere, because that is going to be the jam of the summer, certainly the jam of July. So be here, okay? If you all didn't party hardy for the 4th of July because it fell on a Wednesday this year, and because it was in the middle of a work week and everybody has to be up the next morning for work again, well, this is a Saturday night, July 14th, the 14th of July. We're not celebrating America's independence, but we're celebrating your independence. So come on out and party hardy, everybody. Jam Fam Entertainment Group, one of a number of companies that I own. I'm the owner of that company, and but I don't do all the I practice law, that's about it. But I know that they, as a company, put on a jam, and it's going to be great tonight. It's going to be the place to be. I will be there, Mr. Irvin Hester. If so, can I ride with you? I was hoping to ride with you, bro. Anyway, Daima the Young writes, yes. Okay. Yes. Okay. David Fisher joined us. Hi, Dave. Welcome aboard. Seti Bay joins. I have to be competent. Have to be competent. Yes, Seti has to be competent. Well, that's why it's very important to choose your attorneys correctly. Choose your legal counsel correctly. Choose all of the ancillary people involved in the transaction correctly, because at any point in a real estate transaction, it could all fall apart, and you invest a lot of time, energy, resources, are invested and tied up in these transactions. Sometimes it's the biggest purchase any of us ever make in our lives, if you're not driving a Rolls Royce and a Bentley, that is. But the purchase of a house, it is said, can be the biggest purchase of anyone's life. So as a result of that, y'all know what I'm talking about. Y'all who are on Facebook with me and really rock close to and follow me closely know exactly what I'm talking about. But it could be the biggest purchase of your life when you buy a home, and you got to pick your team carefully and properly. I always tell people, if you got to go to court, don't do it without me. So take me to court. I dare you. I am not only your host of the Hour of Power, Stephen G. James, but I'm also attorney at war, attorney extraordinaire, 30+ years in the game. Attorney Stephen G. James from the law firm of Stephen G. James and Associates, PLLC, a professional limited liability corporation. And you good people, when I am not rocking and rolling in Colombia, South America, or La República Dominicana, in the Caribbean, or in some other exotic land, crunching sand pebbles between my well-manicured toes, I am practicing law all over the United States and abroad to serve you better. And y'all know that. So you could hit me up Monday through Friday, speak to Nora at 646-905-9000, 646-905-9000. That is the law firm of Stephen G. James and Associates. And we work harder to serve you better. It's as simple as that. And, we are here to serve many, if not all, of your legal needs. There are 9 attorneys who work for me. So it's not just me. There are other attorneys who are specialists, or who, I don't want to use the word specialist, I take that back, but who concentrate on different areas of the law that I may not practice in, So just call us for the lawyers you can trust, okay? The law firm of Stephen G. James, that's 646. See, I'm thinking already where Deuce is at. Deuce is in South Beach, Florida somewhere, and I'm thinking 305 area codes. No, it's 646-905-9000, the law firm of Stephen G. James and Associates. But back to our show, we have Seti Bay is saying, but the bank can only lend. Yeah, that's true. I guess you got to put your statements in a more clearer context so I can one sentence statements are difficult to understand what you mean. I see you say have to be competent, but the banks can only lend. Tell me a little bit more about what you're getting at so I can expand upon it. I'm not really sure. Oh, Sharon Key says, so what they do, go back to the beginning of the process. If what? What's your question? If there is a stoppage at the end, or give me, you guys got to give me fuller context. I know that you're responding to something that I said, but if I said it a while back, I'm not sure what you're responding to. So you got to give me a full context of what you're saying. Okay, I'll be happy to talk. And I know, Sharon, you always have good interaction. So just give me a fuller sentence so I know what you're talking about. Seti Tom, also you, Seti Bay. Brother, you know, I know exactly who you are. God bless you. I got to see you in my office, man, just to give you a hug, man. You've been through so much. I respect you, and I want you to stop in and holler at me, okay? Diamond DeYoung, even to sell my other house, my father and I were both on the deed. I had to have the right of survivorship in order to sell because he passed before I sold the house. Right. Okay, that's an excellent question. And that's how I want you guys to write questions in full thoughts so I can understand what you're talking about. If you do it in just one sentence, then I'm not going to know what you're referring to. Yeah, when you and your dad were on the deed, that's Uncle Cleo. And he passed away, of course, before the house was sold. So you couldn't sell the house at that point until the deed was changed from tenants by the entirety, which I'm assuming you guys had, or just two people on the deed without any legal designation, to right of survivorship, which meant once either of you predeceased the other, the survivor, the remaining living person, absorbed all of the legal rights to the property and thereby could sell the property to whomever they wanted to as a single owner. So yeah, that was the proper move. And that's exactly what the law requires, and you did it exactly the right way. So thank you for that thought, Daima. But you definitely need right of survivorship written into the instrument, into the deed instrument, so that when and if the person passes away, the recorded deed, not the one in your hand, because anyone can type anything onto a deed, not that, but the recorded deed with the city or state that the house is registered in and that the ownership is registered in has to have right of survivorship written on it, so that the person who survives the predecedent can then move forward and transact the business, whether it's a sale or refinance or whatever. Okay, great. And that was to sell your house. Yes. Seti, here we go. I'm interested in claiming land to build homes on due to being an indigent. More. And the land is ours by birthright. Your thoughts, please. I know that there is a set of Moorish laws that are on the books that people have claimed rights to and have, in fact, made legal reference to during various cases in the courthouse, whether it be criminal cases, civil matters, land matters. I've heard of them. I do know, however, while I respect those laws and rules, many of the courts and judges around this country do not, and they won't acknowledge the Moorish birthright laws. And as a result of that, that's made it difficult for certain people to transact business on that basis. However, I respect those laws and rules. I'm familiar with them, although I'm not anywhere near, as versed as many people, not lawyers, may be. But many of your lawyers are going to be versed in the colloquial, unfortunately, Anglo-Saxon laws that govern this country now. But let's explore that more. Not necessarily in this forum, but let's explore that more. You know where my office is at, brother. And if you don't, I'm at 87-66 Sudfin Boulevard. That's in Jamaica, New York, 11435, right across the street from the biggest courthouse in the land, the New York State Supreme Court. Okay, right there in Sudfin. Okay, so the big building on 8811 Sudfin Boulevard is the courthouse. I am 8766, across the street and a little bit down the block. Okay, right before you get to the subway, the F train, Sudfin Boulevard exit. Okay, good question, Seti. Excellent question, brother. Jennifer Rebel, The actress, Fournier, joins us. How are you? You know, I'm still waiting to hear about that contract. So, you know, I didn't forget. You want us to represent you in that contract deal. So, you know, as soon as you get that new contract for that movie, let me know. I'm at the ready. Angela Robinson, I do apologize. I did lose you. You'll never lose me, baby. Don't worry about that. You don't have to apologize. You'll never lose me. I'll always be here. Somehow, but on the topic, were you were speaking of the power of attorney. There is a medical power of attorney and there is a financial power. That's correct. The medical power of attorney makes all the decisions due to the client's medical, due to the client's medical and financial condition, medical issues. They must see that there is a financial power of attorney contract before financing any properties, vehicles, or credit cards. And a financial power of attorney makes all decisions in reference to financial issues. So there is a medical power of attorney and a financial power of attorney. Yeah, I get it. Well, that's true. And yeah, you did probably lose the signal and didn't hear that we covered all of those, but you're absolutely right. Angela Robinson is a banker out in the state of Texas, and she is very well versed in this area, and she's absolutely right. What she just wrote coincides with the points that I was making, which is you can have a medical POA to handle all and make all medical decisions. You can have a financial POA to handle and make financial decisions like banking, opening and closing accounts, transacting real estate, buying and selling properties, et cetera, et cetera. That is exactly right. And but the point is that anyone making the power of attorney, the grantor, must be competent. That is the underlying provision of any power of attorney, that the person making it has to be of sound mind, legally sound mind, to make those decisions, because you are in fact giving over your rights to make decisions for yourself, whether it be financial or medical power of attorneys, to another person to have the legal right to make those decisions over you. So you have to be legally competent to do that. And it doesn't require a judge or anybody, actually. You just need to have the instrument drawn up, properly executed. In certain states, they require 2 witnesses. Certain other states, maybe 3. But as long as you follow the underlying legal provisions of how to prepare it, you don't need an attorney either. You can actually do those yourself. But I think most people would rather be comfortable that they had a professional who knows what they're doing, draft it and prepare it. However, you don't need to go to court for that. That's the point. And you can have those POAs done in a day or 2, as long as you have the proper legal predicates, witnesses, signatures, notarizations, etc. Okay. However, the difference between that and a guardianship is that the person for guardianship is adjudged incompetent by a hearing and a state Supreme Court judge who hears the facts, hears from witnesses, makes the determination, and makes a declaration in a sealed judgment for guardianship. That's a different process altogether, and that's a little more involved, a lot more costly than a POA, and a lot more time is required. Okay, and of course the person has to be declared incompetent for that to happen. No one can take you into court by the ear and drag you in there and say, I'm going to have you declared, I'm going to be your guardian. No, it has to be a process by which it's determined that the ward is incompetent. And sometimes, you see a lot of minors in there, children that are born with certain emotional issues or defect, developmentally disabled, and they can't make decisions. They can't handle things on their own. I had a case where I did a guardianship maybe a month ago, and I was working on it again from a botched case from another lawyer who was doing a guardianship for 2 years, getting nowhere, getting nothing done for whatever reason. And the good people finally came to yours truly and my law firm. And we took over the case about maybe 6 months, 7 months ago. And just about a month ago, we got the declaration of guardianship for the grandmother in this case. The grandmother is in her 70s. The ward is 35, but he has the mind developmentally of someone who's about 3 or 4. And she's been taking care of him ever since her daughter, his mom, passed away about 2 years ago when she began the action initially with the other attorneys. And we got the declaration for her about a month ago, and now she's able to move forward with insurance issues for her money that the daughter left for him. You know, they had to put all that stuff in escrow until this guardianship issue was resolved, because grandma wasn't the guardian, didn't have the legal right to control his money, didn't have the legal right to invade that account. All she could do was try and save it. So we had to put all that aside in escrow. And then once she got to the guardianship a month ago, now she can, you know, properly execute on his behalf any of his financial needs. And of course, she's been always handling his medical needs and issues like his mother had been from when he was born. But the point I make is that she could not have had him sign a power of attorney. That would not have been appropriate. That would have, in fact, been illegal. And most attorneys who would have had to have prepared that instrument, or notaries who would have had to notarize the document, would have caught on. He's in such a shape that there are no lucid moments. There are no times where you could have thought that he was a competent person. Even if he came into your office for 10 or 15 minutes to sign a document, you would be able to see. I mean, he can't even speak, and you know, he can't really function without help, serious help of his grandmom at this point in his life. So a guardianship was done, and done very well, and now he's on the road to a successful life with his grandma, where she can make the proper and appropriate decisions about a lot of money which was left for him by way of insurance from his mom to him. You know, we're talking almost 7 figures that they couldn't move, they couldn't touch. So now she can do things for him. And of course, another note, when there's a guardianship, Angela, you notice, and the court makes a determination, chances are good that the court is going to set up the banking situation, because there usually is money involved, wherein it's one of the banks that the court, at least in New York State now, they have a designated list. In other words, they don't allow the guardian to go and pick whichever bank they want, or use the bank that they've always dealt with because that's been their bank for years and years and they have a good relationship. No, the court now has its own selection of banks from which to choose and open an account on behalf of that ward, that charge, that person who you're now guardian of. And the bank and the court are in connection with one another, so that whenever the guardian, who has the legal right to withdraw funds and to use funds on behalf of the ward, goes to the bank and says, I want to take out $100 to buy, I don't know, a winter jacket, or I want to take out X amount of dollars to do this for little Johnny, or little Sally, or little Susie, or little Tamika. The point is that you have to then get permission of the court, and the bank has a designated person who basically deals with these guardianship accounts, who then knows, okay, you can get this money, you can come back tomorrow, or whatever time period they have, and they'll contact the court directly and let the court know that you're making this request. And the guardian is also directed by the court itself to go to court and let the judge know, who granted the guardianship in the first place, each and every time you need to take money out. So it's very controlled and very regulated, although the guardian does have a lot of leeway and a lot of rights. When it comes to actually invading that corpus, that account, you have to get permission of the court, and the courts have now safeguarded the well-being and the monies for those guardians and those wards by being in direct contact with the banks themselves, and having people designated at the bank who will contact the court itself and say, hey, Joe was in here yesterday looking to take some money out. What should we do? By that point, Joe should have gone to the court, and the judge should already know what the bank is talking about. So everyone's on the same page. And if it's a reasonable, you know, and it's normally granted when it's within reason, nothing crazy. But if it's a reasonable amount and the purpose you state you need it for, the court normally will grant it and tell the bank, sure, you can release $100 or $1,000 or $10,000. I've had a guardianship case where people have had in a private home, and let me see if I can think back to this case. It was a private house. The grandmother, again, was taking care of a child, well, of a incompetent adult who was incompetent, and the grandmother had an older home. She had been in this home for 45 years, And the bathroom was one of those one-bathroom, two-story homes with the bathroom on the second floor, no bathroom on the main floor, no bathroom on the basement. And she wanted to have a bathroom installed in the main floor so that the ward would not, who's incompetent and had fallen down the stairs a few times and had accidents too, bathroom accidents, because he couldn't make it up to the bathroom in time before he let her know he wanted to use the bathroom, and she had to help him up. She's older, the whole bit. So he had some accidents on the way to the bathroom, and even had fallen down the stairs a number of times. So she put in a request to have a bathroom installed in the main area, the lower level, where throughout the day they spent most of their time. Basically, upstairs were the sleeping quarters and the bathroom. So in the daytime, they're watching TV, they're eating, playing, doing other things on the main floor. So she went to the court and she said, listen, I need to have a bathroom installed on my main floor. And the judge granted the $10,000. He had the contractor come in also, along with me, and the contractor had to explain his fees and why and justify more or less the costs. And it was satisfactory. The judge wasn't unreasonably harsh or inquisitive. He just wanted to get some clarity on what it was for. And the only issue that came up that I always, it always stuck with me after that, was that the judge was concerned that the house did not belong to the ward. It belonged to the grandmother, and the ward was not on the deed. And the judge tried to make the argument, well, you're making this home improvement for him, but yet you own the house. So you actually are the beneficiary of the home improvement. And I had to argue, because I was representing the grandmom, and the child. And I had to argue that while, yes, she is the record owner, the deeded owner of the property, and she is unwilling to add him to the deed because now he's an incompetent person. She is his guardian. She can act on his behalf. So what is the point of adding an incompetent person for whom you are the guardian already onto a deed when you are the one who's controlling everything anyhow? And the judge understood that argument after he heard it. And also I mentioned that he grew up in this house. This was the house he lived in all his life. He was 30-something years old when he was born. His mom lived there with her mom, his grandmother. And when his mom passed away, he still continued to live in the same house. So what other place would he have lived? He has no homes anywhere on the planet in his name. So this is, in fact, ipso facto, his home. And the judge agreed with that argument. Hello. So we won that one. Anyhow, folks, any other questions, any other issues? This is a very interesting topic for you. Faye Allen has joined us. Hi, Faye, from upstate New York. How are you? Good, good. She's up in the Orange County area. Thank you, Faye. Well, they found, Daima DeYoung says, well, they found the daughter willing to continue the sale. Excellent. That was the person, for people like Faye and others who are just joining us. Daima was buying a home with her family and for her family, and during the course of the contract, but before the closing, the seller passed away, and they, I guess, had to do some sort of ear search or some search of his descendancy or someone who could operate in his stead. In this case, I guess it was a surviving heir, his daughter, and that person, once she was found and explained the situation, continued through with the transaction. They were able to buy the home. Good story. I appreciate that. And this shows you, folks, there's all kinds of, pitfalls and twists and turns in real estate transactions that, you don't hear about from brokers. They half the time, they don't have anything to do with this. And Daima DeYoung, you can tell me if you think I'm correct, but the real estate broker really doesn't really have to deal with this. This is a legal issue now, and it becomes a testamentary issue, correct? So let me know. But I appreciate you sharing that. Faye Allen from Orange County, New York has joined us. Seti Bay says, I'm interested in claiming land to build. Okay, we did that question, Seti. Okay, good enough. North America. Daima DeYoung, but it took a few extra months to continue the sale. Luckily, the contract was completed before the seller died. Right. Well, that was good, because if you didn't have a contract, you'd have no legal standing, no right to enforce a contract, and you then have to rely on whether or not these other people were willing to enter into a contract for sale. But in any real estate deal, under the law, the UCC, you're required to have it in writing. That's state law, and I think that applies around the country. All real estate deals have to be have to be reduced to writing. You have to have a contract for them to be enforceable. Otherwise, they're not enforceable. That's standard in the state of New York and in most other states. Any contracts for which the duration is for 1 year or more must be in writing to be enforceable. I'm giving you guys all this free legal advice. Y'all better come to my office and drop that science on me. Shucks, I got a Rolls Royce and a Bentley to support. I'm only teasing. But yeah, any real estate transaction, in order to be enforceable, Daima and everyone else must be in writing. And thank goodness you guys had already gone past the contract point before he passed away. And also, thank goodness, you found a willing heir to go on through with the deal. And also, thank goodness, no one was trying to claim he was incompetent or incontinent when he signed the contract. Because if he passed away between contract and closing, I don't know what he died of, but some people may claim that he was dying at the time he signed the contract and just hadn't died yet, but he was in, you know, not a good emotional place and maybe therefore not in his right state of mind. But thank goodness that issue did not come up, and the daughter was willing to go through and execute on the contract. So amen to that. Good afternoon, Mr. James, says Faye Allen. Faye, good afternoon to you too. Sheila Jenkins joined us. Thank you, Sheila. Appreciate you. We have Tanya Gwendolyn Vickery. I sure will love you, King of Kings. Amen. Thank you. That's Tanya joining us. Tanya Vickery is joining us from the great state of Georgia. Hi, Tanya. If ever in New York, don't forget to stop by and say hello to us in person. We appreciate you. We know that you are dealing with a number of issues down there in Georgia. Some serious things, you and your two wonderful, lovely daughters. So we'd love to delve deeper into that when you're here in person, because we don't want to compromise your privacy by discussing too much of your personal stuff here. But I can tell you that we respect and appreciate your struggle and your fight, and to victory are God's people. Okay, so amen to you and to your victory. Sheila Jenkins, good morning. Good morning, Sheila Jenkins. Seti, I'm interested in claiming. Okay, we did that. Sabrina Lewis. Hi, Sabrina, the esteemed big boss lady at the YMCA here in Jamaica, Queens, New York. If ever you guys are in the Jamaica, Queens area and you need to ask any questions about YMCA activities, it's a great place to work out. It's a great place to visit. They have a lot of activities. They have a wonderful summer camp program for the young people. My two little guys are going to be going there in a couple of weeks. I highly recommend it. Sabrina Lewis is the lady to see, and I understand she'll be at the big party tonight. So big Jam Fam Entertainment Group LLC victory to you, Sabrina Lewis. We look forward to seeing you. And she ran a very, very successful and great for the children again in the community of Jamaica 3-on-3 basketball tournament last weekend, and it went very well. My oldest son participated in that as well as Sabrina's oldest son, her 22-year-old, and my 20-year-old. So I definitely like the work you're doing, Sabrina, for the community. Thank you, thank you, thank you again. She's a lifelong Jamaica Queens resident, and we respect Sabrina Lewis and all she stands for and all that she does. Anna Rossiter from the great country of Canada is in the house. Hi, Anna. I'm glad you can join us from Canada. How is it today up there, and how are you? Hope all is well. God bless you. It's always nice that you check in. Angela Robinson. So you just have to make sure, depending on the state, if you have to have a medical and financial contract for power of attorney. Right. That's why I said earlier, and I don't know if you had been cut off at that point from us, it's important. You don't have to have a lawyer to do these things, but it's important to have someone who knows what they're doing, and that's one of the benefits of having a lawyer. At least you have somebody to blame if it's not done right. But if you do it yourself, and I've seen people try not just this, but different things themselves, and then they kind of mess up and they have no one to blame but themselves. That's a funky position to be in. You don't want that to be you. What is it that they say about having a client, yourself as a client, has a fool for a lawyer, or something like that? Don't get a fool for a lawyer. You know, try to get a professional, somebody you can hold, you know, that can take responsibility for doing this thing right for you. Okay. But thank you, Angela. That is excellent, excellent advice. Sharon Key joins in and says, yes, because the process of the closing was right on the bank couldn't complete the deal, so they go back to the beginning, right, of that process, right? That process where the first example I was talking about, where the people came to me this week because they got to the closing and there wasn't the proper incompetency document, there wasn't a guardianship prepared. That deal, it could have fallen apart. The only reason why that deal did not fall apart so far, and it hasn't closed yet, is because the buyer of the sellers who had the problem, the sellers are the ones who had the problem, but the buyer lives in the house, so he's paying rent and he's in a rent-to-own situation, and he really wants the property. He's very enthusiastic. So while the bank couldn't close, they can reconvene all the parties, all the players once again down the line when everything is done properly, when the guardianship is finally had, and they can go ahead to closing and all the players are in place. Good point, Sharon Key. Seth Gillespie, I'm sorry for requesting. Same question. I'm new here and not accustomed to you all actually going back to reply to questions. Oh, okay. No, that's cool, brother. I mean, I understand. Don't worry about it. You know, we are family. You know, Sister Sledge, they don't have nothing on us. We are family. We are an international, multinational, worldwide family. And we're brought together in the hour of power, SETI, for a reason. And SETI, Bay, the reason why we did this is because our voices and our concerns and the things that make us unique as a people, and I'm talking about all people of color, not just so-called African Americans or Black people, but people of color from around the world, have been silenced to a large degree in the mainstream media. There used to be shows on on WBLS, WWRL in the New York area, Like It Is, Black News, The McCreary Report, and a whole bunch of others around the country that are now gone, plain and simple. BET is owned by Sumner Redstone's Viacom Corporation, as non-Black or as non-people of color as you can become, okay? When Robert Johnson started BET about 35 years ago, it was started in Atlanta, Georgia. And that was their headquarters, at least. And, it was about people of color, and it was about expressing our ideas and views and opinions, and about programming that was geared towards us, because the mainstream programmers didn't give a damn and didn't have any program geared towards us. So he filled that void with BET, built it up into a powerhouse, and when they saw how powerful it had become, decided to tear it down and undermine it. And the way you undermine something like that is, if you can afford it, like Sumner Redstone, is you buy it and then you redo it, rebrand it in your own image and likeness, the way you want these people to be portrayed. And that's what you have now in BET, okay? VH1, shucks, VH1 that gives us all of these love and hip hop shows, don't get it twisted. I'm old enough and have been around television long enough to remember when VH1 started, they didn't even want to play Black videos. It was started off, VH1 stands for Video Hits 1. You had to have a hit video in order to have your video played on that show, on that network. And it was only playing videos. MTV, music, television, only played videos. Well, they didn't only play videos, they only played videos of white artists. Let's be real, okay? And the white artists that they played were not necessarily gearing their music towards a Black audience. So they were only interested in white audiences and white artists' music. But when they saw things like BET and some of the underground programs like Ralph McDaniels and people like that, Video Music Box, and you'll remember Donnie Simpson, he was from BET, but he was also in Video Music Box, Ralph McDaniel. These were all quote unquote underground shows, just like this show. I guess they would call it an underground show. And as we build our audience up, we know they're watching, we know Joe's watching. And as the show gets built up, right now, they can pay us no attention. But as we build and pick up speed and pick up steam and pick up an audience and start really building, they're going to come knocking. Bop, 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 bop. Attorney at war. Bop, bop, bop. Let me holler at you, player. Bop, bop, bop. Because that's how they do. They ignore you. They try to ban you. They try to keep you out until you kick the door down in your own way, build up your own joint. Then here they come. Let me get that. Basketball had a Negro League. Baseball had a Negro League. Why? Because they kept people of color out. They wanted for themselves. But then when they saw how good you were and saw how you were picking up audiences and how people were catering to your stuff, the rap game, they ignored rap. When I was in high school, they used to run around yelling, rap sucks, Led Zeppelin, you know, Jethro Tull, and all this other stuff. Rap stinks, Run DMC, blah, blah, blah. Well, when Russell Simmons and Def Jam and Puff Daddy and Bad Boy and all these black companies built their net worth up to 8 and 9 figures, they couldn't take it. So what did they do? They started rap divisions in Columbia and Geffen and in RCA and all these different Elektra. They all started rap divisions after about 10 or 15 years of trying to keep rap out of the music business. Didn't want to acknowledge him at the music awards. Didn't want to recognize rap as a real genre of music at these award shows. You know, American Academy of Music, the Grammys, all these things didn't acknowledge rap. They, in fact, went out of their way to try to ignore it. But they couldn't ignore the sales. Okay? Their kids and ours were buying this stuff. Well, I shouldn't say their kids. It was my age group at that time. Teenagers and early 20s buying that stuff. So that money speaks the volumes. Okay? It's the money. So these shows and these things only come about when they see that you can't be held back and that your product is what they want. But they want to control it if it starts reaching enough of an audience. And I saw that these audiences were bought out, what they call co-opted, what we call in real estate gentrified, taken over and rebranded and then repackaged back to us in a milquetoast way. So our voices are not being heard once again. We're back to that period of 35, 40 years ago when we weren't given a voice, an outlet. And that's how these black shows began. That's how these black networks began. That's how these black leagues began. That's how these black radio companies began. That's how these black record companies and rap stations and rap things began, because we were blocked and barred and ignored. And we're back to that again. So the power of our show is there because we don't have a voice once again. What do? Bob Johnson, sold out. All the rap labels sold out. There's no more independent rap labels. You know, you want to be a rapper now, you got to go and knock on Conky's door. You know, and you got to say, Joe, can I rap? Can I get on? Okay, but if I say the N-word 1,000 times, can I get on? Sure. Come on. But when that was black controlled, you didn't hear all this N-word stuff. You didn't hear all that. That was because they took it, rebranded it, repackaged it, and now they're selling it to you as this. You can't make a rap record unless you have the N-word repeated at least 100 times. Don't believe me. Do your research. Do your homework. Check everything I say out. Okay? Check it out. It's facts. We only deal in truisms and facts here on the Hour of Power. And I am your host, Attorney at War, Stephen G. James. And you can reach me Monday through Friday through my office at area code 646-905-9000. We are in Jamaica, Queens, New York today, rocking and rolling with the best of them. But we are heard around the world. This is your international, multinational, worldwide broadcast heard around the globe. In every point that the internet has had, you can hear our voice, the Hour of Power. Praise God. And we continue to do this every Saturday from 12 on to serve you better. We work harder, point blank and period. Okay, let's get back to the discussion, folks. Sabine French has joined us. Hi, Sabine. Angela Robinson, I'm having a bad connection with my phone because of my location. I'm sorry, Ange. Well, maybe you can listen in or go on the internet, go on your computer. You know, we value your participation. We hope that you can get the connection together. We want definitely you to participate. We have John Perry joining us. Hi, John. Appreciate you, brother. Sorry for my typos, says Angela. No problem. Keandra Ambles joins us. Thank you. Carlos Giddy, thank you. Is it Guidi? I hope I'm pronouncing your names correctly. I'm sorry. Carrie Harrington has joined us, and Peter Gray. Hi, Peter Gray. That's my brother from another state who's always been a diehard follower and friend, both on Facebook and in many of the things I've been engaged in lately. So I definitely appreciate you, Peter. I want you to hear that from me to you personally and first. Okay, Peter, keep up the good work. I definitely appreciate your support and your input. Can't do it without you guys. Like I always say, there is no me without we. Okay, all of us out there make this happen. Me by myself, just a speck of dust, but backed by God. Okay, and you guys. So thank you, and thank you again. The Hour of Power is growing every week by larger numbers. We're getting greater participation. We have our mainstay diehard people, but we're also growing more and more listeners, people who don't even check in, but we can register you as a listener because we can see the numbers growing, and we appreciate everything. You know, we are only here as long as you want us. You know, I don't do this for me. To me, this is fun, and this is an outlet to express and to get to know, to express ideas and opinions, and to get to know you guys and your ideas and your opinions. But I only do it as long as you want it. Okay? We are here to serve you. So we only are going to continue to do the Hour of Power on Saturdays at 12 noon Eastern Standard Time, 9, I guess, Central Time, 11 o'clock if you're in Texas, like Angela. And we are only going to do this as long as you allow us to by your participation. So we need you to continue to participate and tell a friend. If you think we have something important to say and worth listening to, tell friends about it. Let them hear it too. Don't hide us behind a bushel basket. That's in the Bible. It's a sin to hide me. Okay? Don't hide me from a friend because that is a sin. Don't mean to rap. Give me some dap. Anyway, Angela says, typo picked up. Oh, no problem. I hear you. Not a problem. Hassan, assalamu alaikum, brother. How are you? That's my Bangladeshian brother. Wow, we are getting people from all over the planet, like I tell you, good folks. Hassan Aziz is from Bangladesh, checking in, and I know he has some good things to say. Let us know your thoughts, brother. Carrie Harrington, Peter Gray, Angela Robinson. I'm in this building, and my connection is so bad. I was text, and didn't put it on my words. I'm sorry. Okay. Wish I could help you, but I can't. Oh, didn't pick up all your words. Sabrina Lewis, good afternoon, Mr. James. Yes, Sabrina, I hope you heard. I just spoke about you very briefly a moment ago. R. Jewel has checked into the house. J. Rainey Harris joins us. Faye Allen, I'm good. Great conversation. You look handsome today. Do I? I can't get this shirt, Faye, to act right. Do I button it like this? Or do I think this part between the second and third button is too long, because when I unbutton it, it's showing a little bit too much. You know, let these muscles start falling out. You know what I'm saying? You all know I like to have my fun when I can. So you all who know me know me. I have fun. You know, because like they say, when it's all said and done, when it's all over, and they start, 6 dudes start throwing that 6 feet of dirt on top of you, if you did not have fun, guess whose fault that is? So I try and have fun whenever and wherever I can. Faye, you know that already. Who else has joined us? Giselle Urania. How are you, Giselle Urania? Veronica Batista, how are you, and welcome. Both of these ladies have joined us. Sharon Key. Oh, she writes, oh, yeah, that's right. Oh, Chase Winship has joined us. Good afternoon, Chase Winship. Blanca Adigan. Oh, yeah, she's joining us from California, Sacramento area. So there, it's about, I guess, 10:20. Am I right, Blanca? ¿Cómo tú estás, mi amor? ¿Todo bien? I hope all is well with you and your son. Okay, send big shout outs to Blanca and her baby boy. Okay, handling her business, holding it down in the Fresno area of California near Sacramento. So good checking in. Who else do we have on the Hour of Power, which is your program, your show? I just host it and keep it together for you. And again, we were talking about real estate transactions and some of the pitfalls and problems that can occur when you're doing a real estate transaction. That's why it's so important to put your team together right. Have the right broker, have the right lawyer, get the right financing. When you guys are shopping for financing, I also happen to be a mortgage broker, licensed mortgage broker as well. So I know a bit about mortgages. And when you're shopping for a mortgage, you want to get a competitive rate. You know, sometimes the rates can vary wildly depending on your credit, but at the same time, there is a range that you want to stay within, because you don't want to run into a situation where you end up maybe losing the property because the rate is so high that your finance, you know, you can't pay the mortgage because you got a rate that's so high and it's causing the payments to be extraordinarily too much. So you must be able to shop rates. And for that reason, some people will use a mortgage broker, or at least consult someone other than the lender, other than the person who's lending you the money, who has a vested interest in the outcome. You know, they have a vested interest in you getting as high a rate as they can legally charge you, or that you're willing to pay, because then they're going to make more money. Sometimes you may end up in a situation where you're paying points. You know, you're paying someone points just to package the loan, just to give you the loan, you're paying money. And then you're paying when you accept the loan. So there's all kinds of variables that go into buying and selling property, particularly buying, because it's the buyer who has to come with all the money at that point. The seller is cashing out now, but the buyer is the one who's footing a lot of the fees. So you want to get your team together, and you want to get the right team in place. Those of you who work in the field, who might be attorneys as well, or who might be real estate people or bankers or lenders, know what I'm talking about, you know? And if you have anything to add to what I said, please join in. You know, I respect everyone's opinion, but I can tell you here and tell you now, it all begins with the good team that you put together to safeguard and protect you as the buyer. In our firm, we represent both buyers and sellers, because as lawyers, we can do both sides. But certain real estate firms represent one or the other, especially outside of New York, where they, in many states, don't use attorneys. A lot of times they have the real estate broker, and their people do one side or the other. So you might have a realtor who's a buyer's realtor or a seller's realtor, and they will handle one or the other side. And in that case, they claim to safeguard the interests of their respective side, their respective party to the transaction. However, as an attorney, and in New York State and other states, I represent both buyers and sellers, so I get to see both sides and protect the interests of my particular client in that particular transaction that I'm in. Okay? But any business professionals out there or people who know about this, feel free to chime in. Blanca, you know, how are you? Tell me what's good. If you have any questions. And guys, we're not limiting, I don't mean at all to limit this discussion to real estate issues, or as we were talking, we moved over into surrogates court, trust and estates issues, wills, guardianships, power of attorneys. I mean, you know, I was talking about all of that stuff, but I don't want to limit our discussion to that. You know, if you guys, I do criminal law. I'd say about 75% of my practice is criminal work. I started off as an assistant district attorney in the County of Kings back in the mid to late 80s, and criminal law where I cut my teeth. Okay. And I've been doing that for over 30 years. So I can answer questions about all those areas. Daima DeYoung, be careful of lenders approving you for more than you can pay. I was offered, what is that, $500,000. Yeah, right. I grabbed my papers and ran. I know that was a scam. I did my financial budget before going to see anyone. Perfect. You knew what you can handle and what you could pay back, and you knew that $500,000 probably would have been way more than you wanted to be responsible for, because ultimately that's your responsibility to pay it back. That's an excellent point that Daima DeYoung makes. Be very aware that predatory lending is to some degree alive and well and still going on. If folks feel that you have a relatively good credit rating, or that the property is worth it to them, they'll loan you any amount of money on it in the hopes that at some point down the line you'll fail, and the property and the money, all the money you pay to them goes back to them, stays with them, and the property goes back to them. So Daima DeYoung is absolutely right. You must be careful. You don't want to jump on everything that you're offered. You should check out your lenders. Again, having your team in place is very helpful. In Daima's case, she said that she did her research. She did her own homework and background on what type of budget she wanted to stay within. And when she was offered $500,000, she realized that that was beyond her budget, and she didn't want to get into that quagmire and risk losing her home and damaging her credit and all the other things that happen when you default on a loan. So she walked away from that. As I think she said, she ran away from that. A good word. She ran away, didn't walk, ran. Well, I advise anyone in that situation to don't walk, but run away. Know your limitations, know what you can handle, know what your price range is. Daima and her husband ultimately did buy a beautiful home, and I think they got over an acre of land and beautiful pool, built-in underground pool, in-ground pool with deck, and a lot of space for parking, and a triple garage, 3-car garage. I mean, just a beautiful, beautiful, beautiful home. Multi-level house, finished basement, all within the budget that she had mapped out for her. So Daima, if I got anything wrong, you let me know. But I think I'm about right in my description of your beautiful place. And kudos to you. You did it the smart way. And I wish you were able to write the book on how a consumer and a first-time home buyer can buy a home, because it's very important to do it the right way to stay out of trouble. See, a lot of times we buy properties, whether it's commercial properties or residential properties for our home or whatever, or investment purposes, and we can get the financing, but have no ability to pay it back, or at least little to no ability to pay it all back. We don't factor that we still have to live, we still have to eat, we still have to take care of our children. If we have children, we still have to take care of our personal responsibilities aside from this new purchase. We still have the same old bills that we had before we saw this house or this property. So you got to factor in how you're going to continue to live your life and pay your previous bills that have been ongoing and now repay this loan. So you have to factor that in. Now the bank and the lender, the mortgage person, is supposed to factor that in, but they're not you. They don't know your life, and they don't know every detail of what your expenses are. You do. So you have to be careful not to get yourself in a situation where you end over your head and you end up not only losing the house, but all the money that you put out there in the transaction, and maybe even have liens put on some of your other property that you may own. So shop with your head, not over it, okay? Shop with this, not above it. God bless. Folks, we are joined by Barbara Abate. Hi, how are you, Barbara? I'm glad you were able to join us today. We are talking about real estate. We are talking about trusts and estates, surrogates issues, guardianships, power of attorney. We discussed the differences between powers of attorney and guardianship proceedings, and how you use them and why, when one is appropriate while the other one may not be, and certain rights delegated under those different auspices of law, under a guardianship and under a power of attorney. So if you're just joining us, those are the issues we've been talking about, but you are not limited to those. You can ask about other areas of law as well. We can talk about wills more in depth. And I advise everyone, by the way, no one knows the lease on life. We don't know when we're going to, pass away, when we're going to be called home, either upstairs or down. We don't know. So I advise all of my clients and all of my friends, and you guys come under that umbrella for sure, clients and friends, to always have a will in place. I don't care how healthy you are, or how young you are, or if you have no children, or if you think you have no assets, okay? Having a simple will, for those of us who don't have a lot of stuff to bequeath or may not have a lot of heirs, just a simple will beats having no will. Why? Because when you die, what we call intestate, meaning without a will, then all of your property and assets and issues have to go through a probate proceeding, an intestacy, okay? That means you have to now get the state involved in your families and your personal affairs to try and figure out what they're going to do with your assets that remain. And you may not think, oh, I don't have a big house, or I do, or I don't have a lot of property, or I do, or I don't have a lot of assets. But if you even have a car or a piggy bank or heirlooms or jewelry or anything that is considered of value, that can lead to issues where your survivors can't dispose of those things without bringing the state in to now mandate how they are to dispose of those remaining assets. If you have bills that remain, okay? Funeral costs, we all are going to have those. So a simple will address a lot of those issues. So I advise everyone, whether you think you have a lot of assets or not, to have a will, no matter how young you are, because you cannot show me the lease, the expiration date on the lease for your life, because you don't know when you're going to be called home. Be prepared. We know we are all going to be called. We know that part. We are all going to be called. So be prepared, okay? Because you don't suffer when you pass away, but the people behind you that you leave behind do. And if you care anything about those folks, try to have a better organization in place for them called a will, so that when you pass, they pretty much know what your desires are. And that's another thing. Don't you want what your will be done on earth? Okay? If you want your will to be done, then you need to write one. Okay? And they don't cost a lot. I mean, a couple of $100 you can get a will done. And even if you have a complicated asset or estate base, you can still get a good will done for relatively cheap. Okay? Certainly a lot cheaper than the aggravation and frustration and problems that you will leave behind without one. Just think Prince, not Prince Royce. What was this guy's last name? The singer. Well, Prince Royce is a singer too, but Prince, I can't remember, the guy out of Minnesota, okay, Purple Rain. This guy had about $600 million in assets when he died. A lot of money, a lot of unreleased albums in his vault, a big estate, Paisley Park. I think his name was Prince Rogers, something like that, Prince Rogers. Anyway, he left a very large estate, and he had no will. And he was young. He was only 50 when he died. He didn't know he was going to get into that elevator and not ever step out again. He didn't know that. But guess what? He stepped into the elevator, and the proof that he thought he was stepping out was he had even pressed the floor to get out on and never made it. Okay? And that led to a lot of problems, a lot of legal actions, a lot of litigation. And of course, the cost of all of that comes from the estate. His estate, his assets pays the judge, the lawyers, the administrators, and all the people involved with putting that estate through the probate action that it has to go through. You have to find heirs. You have to find out who's his brother. I think his name was Prince Rogers Nelson. Yeah, that just came back to me because Haywood Nelson, the old actor from What's Happening, came up talking about that was his brother. And that was going on for about 2 months during the time Prince's estate was being probated. Haywood Nelson is not Prince's brother. Prince's dad, Rogers Nelson, did not father Haywood Nelson, but Haywood Nelson, who was not to be seen on television or movies anytime lately, I guess ran on some hard times, perhaps, and decided that he wanted a piece of that pie, seeing how his last name was Nelson. He was kind of known from the 70s program, the sitcom What's Happening with Rerun and Raj and all those guys. Well, the guy who is Haywood Nelson stepped forward and said that Prince was his brother because Prince's last name was Nelson, or Prince Rogers Nelson. And he stepped forward. And the point I make is that that was more expense to disprove his claims against the estate. The estate had to spend more money. And there were things like that that went on. All of that would have been avoided, and all of that expense and money would have been saved. And I'm talking in the millions. When you're talking about an estate worth hundreds of millions of dollars, we're talking millions of dollars spent just to disclaim somebody's action against the estate for that money. So if you're not Prince Rogers Nelson, but you're Joe Blow, and you own a nice car that you always take care of, or maybe you have a house or an apartment or something, any assets, you know, maybe you even have some old gold coins or some silver dollar coins, whatever. If you take a few minutes to prepare a will or write out what you value and what you want done with your valuables after you're gone, and you go down to an attorney of competence who can organize that in a will form and have it properly executed with the proper witnesses, etc., you'll be saving yourself and your estate a lot of aggravation. I've seen situations where the entire estate was lost just in the litigation expenses, so that by the time it was all ironed out and everything was cleared up and everybody knew what went where, there was no money left to give anybody. The lawyers and the judges and the fees of the court and all that stuff, the administrators had absorbed all of it. Now, do you want to work all your life and have that happen to you? So I advise people to have a will. Okay. I'm attorney at law, Stephen G. James. My phone number in my office is 646-905-9000, 646-905-9000. And this show is The Hour of Power with your host, attorney at law, Stephen G. James. And we are here every Saturday at 12 noon, dropping science and picking up science from you guys. So we do this as a family effort from coast to coast, city to city, and continent to continent. We are heard around the globe. We have people checking in from as far away as India, China, Russia, the continent of Africa, in Nigeria, within Africa, Zimbabwe, Namibia. I mean, South Africa has checked in, okay? And we have Shub Singh in India, Calcutta checking in. We have Bangladesh checking in. I mean, we are all over the world, folks. We are international, and your voice is to be heard. Your opinions are to be respected. And this is your show, The Hour of Power, every Saturday with yours truly, attorney at war, Stephen G. James. God bless you. It looks like our hour of power is just about coming to an end. Was that good, folks? You know, if you think we have a valuable message and a good word, can the people say amen? Can the people say amen? And it's now, we're well past our hour. So by the graciousness of God himself, if no one else has more questions, Sharon Key says, absolutely. I second that emotion, Sharon. Barbara Bate, who joined us recently, feel free if you guys are a little bit shy about joining and saying anything today. We'll be back next week by the graciousness and mercy of God himself, God willing. And I want to just thank you all for listening and say thank you to the fam and to the friends for checking in. We'll be back again from South America next Saturday at 12 o'clock, same time, same channel, with your main man, your main made man, attorney at war, Stephen G. James, the professional. So I am signing off, and we are out. Sheila Jenkins, amen. Can the people say amen? Amen to that. God bless you all. And may God continue to both bless you and protect you until we meet again. God bless. Bye-bye. I see you, Sharon. I see you, Sharon Key. Amen to you and amen to thee. Peace.